good afternoon, and good evening, depending on where you are. My name is Rebecca Andersen, and I'm the moderator and chair of today's event, In the Field, organized by the Young Members Group of Asian Institute of Alternative Dispute Resolution, or AIADR. Now, this is indeed the first episode of the AIADR's Young Members Group's new YouTube series. Now, just a quick run to introduce myself. I'm an international trade and energy lawyer, an accredited arbitrator, and also a fellow of AIADR, and presently heading the legal compliance and sanctions division in an oil and gas trading and refinery company in Singapore. It is a great pleasure and great honor to be able to have a dialogue with Professor Douglas Jones today. Professor Jones doesn't need any introduction for those who work in international arbitration. For purpose of this privileged session I'm having now with him, I would still want to let everybody know that Professor Jones is a top arbitrator, top counsel, and top academic professor. Now, he is an international commercial and investor state arbitrator with over 40 years of experience, and an international transactional and dispute project lawyer. And he holds professional appointments at Queen Mary College, University of London, and Melbourne University Law School. Professor Jones is also an international judge at the Singapore International Commercial Court. Now, it is a truly great honor to everyone here from AIADR to have Professor Jones chat with us today. Now, normally Professor Jones is traveling around the globe because he has offices in Sydney, in Toronto, and he's also a door tenant at Atkins Chamber in London. But today, again, we are fortunate to have Professor Jones sitting together with me in the same time zone, Singapore. But although we are not sitting together in the same room, but we are in the same time zone. Professor Jones, good evening, and welcome to today's event.
Good evening, Rebecca. It's indeed an honor to be the first participant in this series, and I'm looking forward to our chat.
Thank you so much, Professor Jones. And as our time today is only limited to 1 hour, and I have indeed 1,000 questions to ask yourself, and on how did you become so successful as an arbitrator? But I think I have to exercise some selective mode still to only ask you the only pressing questions in my mind. Now, Professor Jones, let me start by asking you, but how did you first set yourself out as an arbitrator? What was your personal experience in this journey?
Well, Rebecca, it's sometimes difficult to pinpoint how one actually develops a career as an arbitrator. I, of course, practiced as a lawyer in Australia for many years before I started to do work as an arbitrator. I was a projects lawyer involved in both transactional, otherwise known as front end, and in dispute resolution work in projects. And of course, almost all international projects have as their preferred method of dispute resolution arbitration. And many of the domestic projects also provide for arbitration. So in the dispute resolution part of my practice, and I headed a quite significantly large team of lawyers operating in Australia and in Asia, being able to understand and effectively participate as counsel in arbitration, one needs to know the arbitrators and the process. So for many years, I've been a member and participated in arbitral organizations and conferences and got to know the process, and of course a lot of the other practitioners, lawyers who appeared against me or as arbitrators with me appearing before them. So that is how I got to understand the arbitral process. And gradually, as I became more senior, I found myself being asked first by institutions and then by parties whether I would accept appointment as either a party appointed arbitrator or as a chair of a 3-member tribunal, or more occasionally as a sole arbitrator. And this was an interesting development in my career, which I rather enjoyed. So I decided in 2014 that I would have a sea change and try to practice solely as an arbitrator without any counsel work. And that led me to move from my law firm into a separate practice as an arbitrator. I've been blessed with a number of appointments as an arbitrator, and I found the change to be quite significant, really. It's a different mindset to being an adjudicator to being a counsel. But it is extremely interesting, intellectually stimulating and exciting to be an arbitrator. But to put my finger on how did I get my arbitral appointments is a quite difficult thing. One doesn't always know where they come from or why people have chosen me as a party appointee or as a chair. So I'm not able to give you a magic formula just to describe my journey, which has been to establish bases, firstly in London, where I think there is a lot of English-speaking arbitration practices centered. And then in the region, of course, Asia is becoming an increasingly important part of the international arbitral scene, given the trade flows in the world. And then a few years ago, after my wife passed away, I married another arbitrator, a law professor from Canada, whose husband had also passed away. So we have a home in Toronto where 6 of the grandchildren are, and I have a home in Sydney, Australia, my favourite city, and I have a home in London. And the London base has been quite important in the development of my practice, I must say.
Yes, yeah, it was most fascinating life journey actually, and I think that with the miraculous questions or the magic formula, that is all us that we're seeking to hear. But of course, that I think one will have different formula as to the magic formula. But I think yours is pretty unique. So the second thing that I like thinking about yourself is that, Professor, and you are a professor and have been teaching in one of the world's most renowned university, Queen Mary University of London. So do you think that having that background as an academic like yourself puts oneself on a more regarded manner or to be appointed as an arbitrator?
Well, I think it depends which jurisdiction one's talking about. Certainly in Australia, I think there is a healthy disrespect of legal academics. And of course, I'm not a full-time legal academic, as my wife is. She sits as an arbitrator, but she's a real professor. I'm a part-time professor. And I don't think in Australia people look for academics as arbitrators, but it's quite different in Europe, where academics are deeply respected for their sense of judgment. And there are a lot of arbitral appointments made in Europe of arbitrators who have never practiced as counsel, who are respected for their knowledge of the law and knowledge of the arbitral process. And so it varies from jurisdiction to jurisdiction, the extent to which academic qualifications are regarded as useful for the appointment of arbitrators. For me, I don't regard my teaching as a promotional exercise for arbitration. I've always tried to teach since I was a young lawyer, because I find it's a great discipline to keep up to speed with the law. To have to teach it is a necessary, you have to understand it.
Yes.
So I've used that as a discipline, and I've found over the years that I really enjoy teaching. It concentrates the mind on what is the law, how to communicate
Yes.
to others, important aspects of what it is you're seeking to teach.
Yeah.
So I'm a part-time academic because I've enjoyed doing it over the years, but
Right.
I'm not sure that it itself has enhanced my career as an arbitrator.
Yeah. Yeah. So I actually share your same interest, and I really have a passion like that as well as in teaching. And of course, that I hope to get there one day, like yourself, to be able to teach or even to be adjunct teaching assistant or lecturer. Yeah, this is something that's always in my mind that I think I probably might want to do one day, and I have the requisite or enough knowledge to teach others. Yeah. So another thing that I was just thinking about is that, and these questions has always crossed my mind, that how important do you see a mentor to one's career as an arbitrator? And this is because I observe there have been a lot of mentorship program in the arbitration space, and a lot more than other career or professional industry. Why is that so, Professor?
Well, I think mentors are really important in life
Mhm.
and in practice. I've had some pretty important mentors in my own career, and a number of them have been arbitrators or senior lawyers who I've worked with and watched and sought to emulate. I also find mentoring is a hugely satisfying thing myself as a mentor.
Right.
And in my legal practice and now in my arbitral practice, I have sought to have working with me young, bright, enthusiastic lawyers who I can work with as they develop. And there is a bit of a diaspora of people who I've mentored. Some of them are judges, some of them are very senior counsel now. But it is one of the most satisfying things in life to watch the growth of an individual throughout their career. I've been less than enthused, I must say, at the mentoring programs within the arbitral community, sadly. Not because of any disagreement in principle to the concept, but because there is a real difficulty that I've encountered as a formal mentor within programs, such as the ICA mentoring program, of actually finding the time and space to usefully contribute to the mentoring process. Obviously, even where you are within the same jurisdiction. I mean, the Chartered Institute of Arbitrators has a potential mentoring program, as others do. So if you are based in one place, which sadly I am not, I'm a bit of a nomad when it comes to arbitration, traveling the world. But assuming I was always in one place, as I have been, I've found it difficult for the mentees and the mentors to have the time to actually effectively communicate. Even with aspiring arbitrators coming to hearings to learn about the process with the consent of the parties, of course.
Right.
Their availability to attend hearings has always been a difficulty in making it work. So enthusiastic though I am on the concept of mentoring, and bearing in mind that I've tried in a number of these programs to contribute as a mentor, it just hasn't worked as well as I would have hoped. My own career of taking advantage of mentors to me has been that just to take the opportunity when you find someone that you are working with, you might be appearing before them as an arbitrator, you might be working with them in a more senior role within a law firm or another form of practice, just to suck up whatever experiences one can to learn in that process, rather than necessarily forming a formal link. So I think mentoring is a two-way street, but it is a really important part of a mentee's experience to take whatever advantage there is of whatever opportunities might present of senior people who they might respect to learn from whenever they get the chance.
So when you actually be a mentor, and I guess all the time you're assuming the role as mentor yourself, you would then be part of a program under an arbitral institution, and then there would be a mentee applying in to be a mentee. So
that's how those programs work, but they've not worked well in my experience. I've always felt dissatisfied in my capacity to truly contribute as a mentor within those programs. I would say, though, for the people who have worked for me, the young people over the years who now are no longer young, who I regard as my mentees, that in working with them, hands-on, of course, in matters and the like, that my contribution to their career development has been able to be much more effective than part of a formal mentorship program. Yes, I think it's a great concept, and those of us that have experience to offer should try and do our very best to offer that.
That's right. So then the questions, the next one I have been, and this is also the questions that I've been always very curious myself, is that what is your viewpoint about an in-house lawyer? I am in-house lawyer myself, having the difficulties of being appointed as an arbitrator, because I saw that it is a true phenomenon going around now. And what are your views about that, Professor?
Well, it's an interesting segue into a bigger issue, I think. And that is, when I first started appearing in arbitrations, particularly because I was practicing in the project space, the arbitrators I was appearing before weren't lawyers. This was in Australian domestic arbitration in construction projects. In my early career, they were engineers and architects who had moved from their practice as engineers and architects to become arbitrators. Many of them were full-time arbitrating, having moved on from their professional careers. And quite frankly, the way in which they ran their arbitrations was as good a process as you will see in the very best arbitrations today. And the concept was, as it has been in a number of other industries, that people familiar with the industry would decide disputes within the industry, not just familiar with, but respected as having a level of judgment and seniority, if you will, that would enable their decisions to be respected by the parties. It's been thus in the maritime space, in the commodity trading space, in intellectual property and computers, and of course in construction related activity. But the lawyers have taken over.
I guess so. And the practitioners.
Well, that's right. Practicing lawyers, counsel in law firms and counsel in separate practice at the bar, have and retired judges have sort of dominated in the last 15 to 20 years, the appointments as arbitrators, to the significant disadvantage of people like yourself, who you're a lawyer, but you are also a busy participant in a very important industry that does generate a number of disputes. And the contribution that you can make as an in-house lawyer to resolving disputes, bringing with you an understanding of both the commercial and the legal side of your industry, is, I think, very significant indeed, and potentially would exceed the capacity of a lawyer to properly understand and adjudicate disputes within your industry. Yet you don't get the opportunity because lawyers appoint lawyers who are practicing in the field, or they appoint retired judges. And that has changed, in my view, the character of arbitration. And it's a sad thing. I've sat, fortunately, as an arbitrator with professional people who aren't lawyers. And they have added huge value to the tribunal process. The difficulty comes from a number of sources, I think. Lawyers trust people they know. They like certainty, and they can see, they have relationships with even counsel who've appeared against them. They understand the way judges have performed in court, and they tend to take the decision for party appointments on the basis of safe, familiar ground. And when one is looking for a chair as a party appointed arbitrator, one is also looking for someone who can perform in that role. Institutions have an opportunity to go beyond that bias of familiarity in appointments when they get the chance to make appointments. But I've never had an institutional appointment in an arbitration in which I've been a party appointed arbitrator. It has always been an appointment by agreement between the two arbitrators in conjunction with a consultation process with the parties. So institutions don't get a lot of opportunity to appoint chairs of three-person tribunals. They do some, but not a lot. The sole arbitrator appointment area is where they do a lot more appointments as a percentage of appointments. Parties are less likely to agree on a single person than they are upon their own appointee. So I think there's a chance for institutions to do more, but are the institutions contributing to this diversity of expertise, shall we call it? The institutions, to me, just seem to be focused on gender diversity, a very important issue, but only one aspect of diversity.
I'm totally with you there, because I have actually, and someone actually asked me the questions, and I have discussed these same issues in one roundtable discussions not very long ago, last week, and whereby we discussed about the gender diversity and vis-a-vis this appointment of arbitrators being focused on practitioners. And one of the issues has been raised was that in-house lawyers or others professions in that matter that is actually beyond practitioners, and whether the institution is doing enough. But the thing is that, of course, the institution will have some visions or some statement to say that they are including all, and they are very diverse, and to include everyone. And particularly the diversity actually, and we've noticed that is focusing more on gender. And on gender in that sense that there are a lot of women arbitrators, but we are still talking about arbitrators from a particular settings, a particular profession. But there are a lot of other factors that we have not been really diverse yet, and which is one is the profession, the background, or the specialities of the arbitrators who are to be appointed, and that is still much to be done and to be improved. And as Professor rightly pointed out, party appointment would very much be someone who like to recommend or appoint or suggest companies or even client to appoint someone else that you know, or you have worked together before, or you work with no problem before. But to try out someone just because of that you don't know them or they have not created a profile before, that I think it has to come from a higher, institution or a body, instead of one or two people can make the difference. And therefore we and the group discussions, the think tank group thinks that institutions has a lot more to do.
I think there are some institutions
Right.
who are particularly focused on appointing members of their industry. If you take the London Maritime Arbitrators Association, the LMAA, which has more London-seated arbitrations than any other institution in London. Their figures are enormous, relatively speaking. They do not accept as full members people who have a counsel role in disputes, nor do they appoint retired judges as full members. Their members are taken from the shipping industry, the shipping brokers, the shipping masters, and the ones who have been involved in maritime contract administration. So you will see amongst the appointments that they make as an institution a much greater diversity of expertise.
So maybe much more need to be done as well as to that respect. Yeah. So now, besides the challenge faced by in-house lawyers and who wish to set path in arbitration career, and in fact, I think it is the same difficulties felt by other professionals who are not legally trained, and especially those who are engineers and accountants, who equally found themselves there was not enough acceptance of them in the arbitration career. What is your thought about that as well? And then would it be the same as in-house lawyers' challenge, or are they slightly different?
I think it's much the same, although in-house lawyers have the advantage of being lawyers.
Yeah.
Whereas accountants, architects, engineers, project managers aren't lawyers. So they probably have a significantly greater disadvantage. And they also have a great contribution to make. And it was from that group, of course, that I first met arbitrators in my early career. The key to their success, and they have to work a lot harder to get appointments than lawyers do, I think, is a demonstrable capacity to handle the arbitration process efficiently and with confidence. I do recall in the early stages of my career that these non-lawyer arbitrators were often criticized for being responsive to being monstered by counsel. That is, they could be, it was said, intimidated by senior members of the legal community, and that led to processes that were less than efficient. But my own experience was that the really competent managers of the arbitral process who came from other professions, they handled these monsters very effectively, very effectively indeed. As well, I would say, as judges would, and those were my role models, really, in my early time, my mentors in a way. They didn't sort of take me under their wing in a formal sense, but the experiences that I had with them really were very formative in my early years.
So I guess maybe another thing which is very helpful is that network. And as someone did talk to me about, is actually network, and network. So that probably will be the more informal way to get your capabilities out there, so that people knows that you know so and so, and therefore the appointment would be much more smoother in that sense.
Yes, I think networking is an important part of success as an arbitrator.
Yes.
I think there is too little science behind choice, and what's top of mind tends sometimes to produce the suggestions. So staying top of mind is an important thing.
Yeah. But so what is the most essential skills at all, Professor, you think that one should have, or one should acquire to have to be an arbitrator, the most essential skills?
Well, in terms of skills, I think critically it's an understanding of arbitral procedure. It's understanding how to effectively run an arbitration. There's a lot of concentration when you talk about skills on writing awards, and that's very important. But the writing of the award comes after a long and sometimes acrimonious process of procedure. And being able to organize the procedure in a way that is efficient and expeditious and fair is absolutely critical. So understanding how to deploy a theoretical knowledge of the practice of arbitration is the first and most important skill, I think. The second is judgment.
Yeah.
I think some people have judgment and some people don't. I can't quite put my finger on how you learn judgment, but it is a skill that is critical. I think another skill that's very important is humility. I think one of the problems that beset judges and arbitrators is a developing sense of divinity. I think there is nothing special about an arbitrator or a judge. It's their job to make a fair process work and make a fair decision. And maintaining a level of humility is, I think, really, really important. It's also important, I think, to have to hone one's sense of humor, because I think you run into quite a bit of aggravation in the process of arbitration, aggravation between parties and the like, and being able to defuse that, if possible, is an important part of the process.
And that's so good to hear from you, and that is quite new to me, that a sense of humor is also one of the skills, and that shows that the arbitrators has a critical role in actually also diffusing some aggravation during the process.
Yes, I think it's very important. There's a lot of aggravation in some arbitrations, and of course the lawyers are to blame for exacerbating that. Although parties who come to arbitration have reached the end of a process which has impacted severely their relationship. But arbitration is designed, as opposed to court proceedings, to provide the opportunity of a decision on what can be a pretty critical commercial issue, but will still leave the parties with a relationship. And that's very important. Not to allow parties who want to have a continuing business relationship to have a complete commercial divorce. it's and arbitrators can help with that, I think.
Oh, this is interesting. Yeah, but Professor, I mean, due to the lack of publicity in the arbitration industry, and hence there's a lack of transparency, how does the public know, or what should the public rely on as informations in order to make an informed choice of an arbitrator?
Well, that's a very good and difficult question.
Yes.
It is said that one of the great advantages of arbitration is confidentiality.
Mm-hmm.
Now, the surveys that are conducted of users do indicate a significant interest in confidentiality, but not an overwhelming one. I think if you look at the Queen Mary survey over the years, confidentiality is said to be, it's above 50%, but it's certainly not in the 90s. So it's not every party or every dispute that requires confidentiality, but we are committed as a group internationally of arbitration players to the concept of confidentiality. So that means that it's very difficult to work out a way to enable parties looking to identify performers, seeing how they perform. Of course, it's different in the investor-state dispute context, where most of the disputes and their outcomes and their awards are published, either formally or informally. But you find out and you can read the the difficulty, though, with that is that it's a very, very small percentage of arbitrations when you count ISDS and commercial arbitration together. I often say that there are more doctoral theses written on ISDS than there are ISDS arbitrations.
Okay.
And the reason for that is obvious, and that is that researchers doing their doctorates can get the information because they're published. So the ICC, for instance, and other arbitral bodies have been seeking to get agreement from parties to the publication of awards, redacted or otherwise, but it hasn't really got a lot of traction. Now, if you could get copies of the awards delivered by arbitrators, you could see from those awards how long the process took, how the procedure was organized, because of course in an award you need to describe the procedure. They would also see how long it took to deliver the award, and they would also be able to see the quality of the awards. But this is, shall we say, a work in progress. And so you identify a difficult and very important problem. Transparency is the touchword of a lot of debates nowadays, including in arbitration. But transparency collides immediately with confidentiality.
Exactly.
And finding a compromise with that for a satisfactory resolution of that collision is something that we need to do a lot of work about, because at the moment the information that's available is what you see from networking events. It's what you see from CVs, and the value of that information is sometimes flawed.
So that actually brings me to my next questions. What are the aspects that you think, Professor, that the arbitration industry should improve on first, that public interest, so that the public interest can be better served?
if one goes to international arbitration conferences, you can be certain that at least part of the conference, if not the whole conference, will be devoted to the solution to problems in the arbitration process. And it's been thus ever since I've been going to arbitration conferences. And that in itself is good. However, if you take apart the issues which are said to be the problems that need to be solved, they always have seemed to be the same problems. So you'll have a debate about how long arbitrations are taking.
Yes.
You'll have a debate about how long arbitrators are taking to deliver their awards.
Right.
You'll have a debate about how do you avoid hugely expensive processes of document disclosure. You'll have a debate about how do you avoid expert witnesses passing like ships in the night and providing no really useful basis for tribunal decision. You'll have a debate about lawyers writing witness statements rather than the witnesses, and using the witness statements as submissions when they're just meant to be providing facts.
Okay.
And you'll have a debate about whether there should be used in arbitration the same pleading, shall we call it, or exchange of parties' cases process to that which you would find in a court, to which with which the lawyers acting in the matter are more familiar because of their domestic experience. So they represent the sort of issues which have been the subject of debate for a long time.
For a long time.
For a long time. And I frankly have a view, and in-house lawyers have a bit of a sideswipe in this view, that we need to find a way of walking the talk instead of talking the talk. Let me give you an example.
Sure.
There are some in-house lawyers, of which you are certainly not one, who speak at arbitration conferences and say, it's hopeless that we have such long arbitration. It's hopeless we have such expensive arbitrations. We need reform of these processes. And they say that in the context of disclosure and witness statements and pleadings and all the subjects that we've identified as what we've been talking about.
Yes.
And when you see them, as I do occasionally, sitting beside their counsel, appearing in an arbitration before me, there's not a lot of walking the talk going on.
No.
Because to a certain extent, they do what their external counsel suggests they should do.
Right.
I don't know whether it's always the case, but sometimes it is, because they're afraid of being criticized for making brave decisions.
Right.
What do we do about it? How do we walk the talk? My own view is that it's up to arbitrators to do it. And I find that one of the most satisfying things about practicing as an arbitrator is finding ways to solve these problems in the arbitrations by persuading counsel and parties to adopt processes which actually help to solve the problems. And I'm quite proactive in trying to firstly devise a process for each arbitration that suits the dispute, and then being very hands-on during the process to try and ensure that as it develops, the procedural problems that create these issues can be solved.
Right.
But that requires arbitrators to actively try to persuade parties to adopt a better mousetrap.
Right, right.
And the appetite of arbitrators to do that is not uniform, sadly. I don't want to be misunderstood. I regard the ARB-MED debate as a bit barren. Obviously, facilitated settlement is a great subject and should be debated, but I think every arbitration involves mediating the procedure and then deciding the dispute, so that you don't dictate what the parties will do, but rather you talk them through the processes which might provide an opportunity of being more efficient than their counsel or they first thought they should be using for the dispute. And that takes a lot of effort by arbitrators, rather than say, oh, I've got an appointment as an arbitrator. That's a wonderful thing. The parties say they want to do this as the process, so I'll just do what they ask, because I don't want to upset them, and it's the party's process after all. But the principle of party autonomy, which is said to be sacrosanct to arbitration, is often better described as lawyer autonomy. You would understand this as an in-house lawyer very well.
Yes.
If the lawyers say, do this, you might be reluctant to say, no, I want to walk the talk. And therefore, arbitrators should try to involve in the debate about effective procedure the clients.
Right.
Just make sure they're there. Just make sure they're listening. And then at an appropriate point, let them ventilate with their own counsel what the suggestions are that the tribunal might be making, so that it's a proactive mediation process to get a procedure which parties are happy with, or at least are prepared to live with. So my long answer to your question, how do we solve these problems? We know what they are. We know what the debate is.
Right.
It's a matter of actually getting arbitrators to apply principles that everyone's talked about to make it work.
To make it work, yeah. I think we surely need a lot more arbitrators like yourself, Professor, and the world needs more like you. Yeah.
No, I'm not alone in that objective, I must say.
Yeah, but so it's actually very fascinating to hear about this point that I probably have not heard before from my fellow arbitrators associates. Yeah, inspiring. So Professor, what is actually your advice? Because this series today obviously is young members, and I think there are a lot of our listeners, our viewers, they are actually young arbitrators, or even young in starting as the arbitration career, young in not necessarily by age, but young in this space, this industry. So what is your advice to the young arbitrators out there in especially in this topic of arbitration?
Well, it depends from which angle one's approaching a career. The majority, I suspect, of young people wanting to practice in international and domestic arbitration who are lawyers is to do so as counsel in the first instance. Develop their skill set, become known, and move from that into the arbitration space. But that takes a career. It takes for someone who wants to qualify as an arbitrator without any counsel experience or any experience as an expert in a particular industry, it's a big ask. Some of my young mentees, some of the people who work with me as tribunal secretaries say, well, I would like to build a career as an arbitrator as soon as I can. And the path that I suggest for them, apart from learning about arbitration procedure, is to do so by seeking to establish an institutional career, that is a career in administering arbitration, become known in that role by counsel and others, and then from that base move to the possibility of seeking to become young arbitrators. And there are a number of people who I would regard as young, who have succeeded in doing that. They've moved from institutions to practices as an arbitrator, and many of them are doing quite well. But for every person, there's a different answer. And I would say understanding the law and practice of arbitration, understanding the networking opportunities that exist, finding a capacity to work in the field are all part of the toolkit that young, aspiring international and domestic arbitration practitioners should follow. There is, of course, a very important part of that process, which is a combination of networking and learning, and that's institutions.
Professor, you're saying that one of the ways for those people or young aspiring arbitrators to accredited but not appointed yet to set their career in arbitration is that to attach themselves with an institution. And that means that, do you mean they have to seek job with institution as counsel or as any capacity?
Ultimately, yes, but there are also internship programs that can be undertaken.
Right. So presumably they are not so young as to undertake an internship. So would you advise them to do some something which is totally not related to being a counsel?
That wouldn't be my first suggestion. I think the counsel path is a far steadier and more prospective path, but it is possible to have moved very early from a counsel role, or not at all, into an institution, get a senior position within the institution, and then go out as an arbitrator.
I see. Right. Yeah, I also conscious with the time. Now, Professor, it has been a fascinating conversation with you, and thank you so much for so many remarkable comments and advice from you. And I'm sure whoever watched this video and our conversation today will enjoy it a lot and tremendously. And I myself truly learned a lot from you. So I would now, unfortunately, will have to call an end to our conversations. And I want to thank you so much again, Professor, for your time in these conversations, and my true great pleasure sitting here talking to you.
Well, thank you, Rebecca. You're too kind. It's been a great pleasure.
It's been a great pleasure, Professor. All right. Thank you. I wish you a good evening, and thank you everyone for watching this video. Thank you very much.
Bye.
Bye-bye.